morning. Please be seated. This is the time set for oral argument in Warner against Phoenix. Our cause number 1CA CV15-0863. Good morning, Council. As I'm sure you're aware, we have already read the briefs, consulted the record, and conferenced this case before coming into argument, so bear that in mind as you begin. We will be audio and video recorded today, and those recordings will be made available online shortly after the argument. Each side has 20 minutes for oral argument. The appellant may reserve as much of your time as you wish, but you're responsible for watching your own clock. And with that, you may begin.
Good morning, Your Honors. May it please the Court, my name is Peter Warner. I'm here representing myself and my wife. My daughter has school off today, so I brought her along for moral support. And because my wife is home with one of my other children that's sick with the flu. And I have another son today, and he's in high school. It's his 16th birthday. What does that mean to a 16-year-old boy? He thinks he gets to get a driver's license. But that is not a right. He may, as a 16-year-old, have a right to apply for a driver's license, but it's a privilege to have that license. Similarly, when it comes to a land variance, a homeowner has a right to apply for a variance, but he's not entitled to that variance unless he passes certain tests, just like my son has to pass certain tests in order to get his driver's license. Now, what we got here is a situation where on a variance, the owner must present competent and credible evidence that the variance wouldn't be materially detrimental to the adjacent property. There was no finding made by the hearing officer. There was no finding made by the board that the variance would not be materially detrimental to the adjoining property, even though evidence was submitted by the adjoining homeowners saying that this is going to have a materially detrimental effect on the value of my property. And that's competent evidence in the courts in Arizona. But when the matter got to the Superior Court pretty much saw that. So the Superior Court went back and looked at the record. And the Superior Court said, well, all these other homes in the neighborhood, there are other homes that have apparently been awarded these variances. And this property that's at issue here should have the same, and he puts the phrases together, you should have the same rights and privileges as everybody else in the neighborhood. Therefore, it's not going to have an adverse effect on it. Well, when you boil that down to basically, well, first of all, that would be like my son saying, hey, all these kids in my class that are 16, they all got driver's license. I don't need to take the test. I don't need to pass the test. Just DMV, give me my driver's license because everybody else has got it.
Isn't there evidence here, though, from which the board could conclude that it doesn't materially harm the adjacent property owners or the neighborhood? If you're going from a lot that has a vacant, uninhabited residence, it's presumably not the most attractive parcel in the neighborhood, wouldn't the board be at least entitled to consider that these parcels are going, if we make two parcels with brand new homes, that that's not going to decrease the value of the surrounding properties?
2 points on that. First, in this situation, there was evidence that the two homes would decrease the value.
The evidence meaning that the neighbors just offered their view that it would decrease the value of their home.
Which is competent material evidence that must be taken into consideration. That's number one.
Yeah, but if they did take it into consideration, you did get a hearing on this, correct? Do we revisit a determination? They considered that evidence and also considered evidence that there will be two new homes on this property. Do we not have to defer to that factual determination?
No, number one, they've never acknowledged neither the. I will respond to your question, but first of all, neither the board nor the judge, the Superior Court, acknowledged those facts. Never discussed them. Number two, the issue is not whether there's whether it's a vacant piece of property versus two new homes on the property. It's whether one new home versus two new homes. That's the consideration that should be taken into effect.
But if I understood your argument was there competent, or at least the issue is there competent evidence before the board that this would not be a material detriment to adjacent property? Now, you said there's evidence that shows it would be a material detriment. Understand that. But if there's contrary evidence, and they're right, then it's up to the board to weigh that. Right?
Yep.
It's up to the board to weigh those two things.
Yes.
And decide, which way is it? And we're not supposed to substitute our decision for them on weighing evidence.
Okay. But Judge Kessler, if you look at the record, what is the evidence? There isn't any. The only thing you've got, and the word is even used in the decision of the hearing officer. He speculated. His speculation about what this developer and his own personal knowledge is not competent evidence. It needs to be something that's competent and credible, not something, hey, I know a couple years ago.
But isn't that exactly what the neighbors are doing? Aren't they speculating? Why is that different?
Because
did they come in with someone that they didn't come in with appraisals that said our home will be worth less? And even then, right. It's a speculative.
Number one, they don't have to, because they are entitled under the law to give their opinion, and that's competent evidence.
So
number two, it's not their burden.
Okay, but you're saying that's competent evidence. So why isn't it competent evidence for someone to offer an opposing view?
They're simply offering the evidence. The only evidence they're offering is that I want to divide the property into two properties so I can put two houses on it. That's all that's being offered. And there was, and the evidence was, that's not. All they're saying is we want a variance because we want a variance.
Well, but I mean, the facts before the board included that, right? That it would allow a vacant lot or a vacant house to be torn down, two custom homes to be built, each valued at more than $1 million, and consistent with the architecture and square footage of neighboring homes, and with a reduction in the width requirement on the lot. But well within the size of the other lots. Okay. Why isn't that competent evidence to observe that and say, okay, this is what's going to happen, and weigh that against your testimony, the testimony of the homeowners saying, no, this is going to hurt my property value? Why can't the board weigh those two things?
First of all, that it was if the court will look at the record. It wasn't two $1 million homes. It was two $600,000 homes. Okay. But okay. And I guess my response is what the board should be looking at is that property will be used for something. It won't remain vacant. That's just common sense. And what will it do to the value of the homes is if you instead, rather than putting two homes at $600,000. You could put one home that would probably sell for $900,000.
Well, we're talking about common sense and probabilities in this argument. Should we be too bothered that people intuited the effects of real estate development in the proceedings below?
Yes, because, Your Honor, you're not, because it's not, what is the, I think you got to go to the next question that's before here, which was the other issue, is whether is the variance preventing somehow, is it necessary for the preservation and enjoyment of substantial property rights. And 2 homes on the property instead of 1, that's not necessary. You don't need to put 2 homes on there for the protection of any substantial property rights. And that's a separate specific
When do you
requirement.
ever necessarily need something when you're asking for a variance? I want a variance to build closer to the property line. I could still live there without getting a variance, but that's the point of the variance is, I mean, it's not that there is some use that can be made of the property without the variance.
If you have a property that doesn't fit within the zoning requirements, and you cannot build a building, for example, on the property, but for getting the variance, that would be a situation where you would need the variance. Here, you do not need the variance. A single-family home can be built on that property.
I guess it depends on what prism you look at it through. I mean, it's not often that we hear arguments here that the city of Phoenix is under-regulating. But that seems to be your argument. And if the underlying premise is that private property rights have meaning, and that the regulatory power of the government should be used sparingly, only to prevent concrete harm to others, it would seem then that a reasoned view that new quality development will not harm neighboring landowners is difficult to attack.
Well, it's very easy to attack. I think, Your Honor, you never want to disagree with the judge.
Well,
but we've got a zoning
you're allowed.
ordinance here.
It's okay.
We have a zoning ordinance here that is that is set up by statute, and that zoning ordinance must be enforced.
But that presumes that you can show that there's a detriment. And when you look at the properties immediately adjacent, directly behind, they look to me to be pretty much the same size, and they're split in half. They have the exact same frontage. Your argument is essentially that those properties bring down the value of the neighborhood. They should never have been entitled to have lots that size. It seems hard to make an argument that the neighborhood is damaged when there are other lots that have even less width to the property. It seems like the 1 acre part of it is more significant than the width, given the number of homes in the area that are at least are narrower than what the revision allows.
And the court just fell into and Your Honor, you just fell into the same trap that the Superior Court judge did. Just because another property has a variance on it doesn't mean that property is allowed to a variance. Each one must be entitled to a separate. You need to look at it separately.
Isn't it evidence, though, that goes to how much damage there will be to other neighbors, if any? And why isn't that something that the board can consider?
Because there's separate requirements that you need to look at. Yes, it may not affect the property, may not affect the neighborhood. But the issue is, it needs to be looked at, does it affect this specific property next door? What if instead there had been a variance for, say, putting in 20 hogs next to the yard?
We don't have the people next door here who are arguing about it. Aren't you making an argument on behalf of the whole? You're not an adjacent property owner, are you?
I'm down the street, and I vehemently think that this thing's going to decrease, putting more homes is going to increase the density.
Let me. You raised. I'm sorry.
No, go ahead.
You raised a point about everybody's got to have. You don't compare the different lots, I think is what you were saying. And I guess part of the problem is, and tell me where I'm wrong on this, okay? ARS section 9-462.06 G2 says a variance is appropriate, as I understand it, stands for the position that a variance is appropriate if, quote, because of special circumstances applicable to the property, including size, shape, topography, location, or surroundings, the strict application of the zoning ordinance will deprive the property of privileges enjoyed by other property of the same classification in the same zoning district. How does that impact on your argument that, well, just because other houses have gotten similar variances or a similar location or similar size and width, that doesn't mean they're entitled to one?
The law, Your Honor, in the Pawn First case states, and I think it's quoting the District 2 case, the Ivanovich case, that the variances that, again, just because another property in the area has gotten a variance,
Grant, but
you can't,
Right, you just don't
it's going to be,
you don't
everybody gets
automatically-
it. The zoning ordinance just goes away.
right, now, you don't automatically come in and say, my neighbor got the variance, I'm entitled to variance.
Right.
But the statute still applies, right? The statute says we look at all the circumstances and see if other property in the same zoning area, including the size, shape, topography, location, surroundings, strict application of the zoning ordinance will deprive the property of privileges enjoyed by other property of the same classification, the same zoning district. That's a factor. That's the test, right?
No.
Oh, so you're saying we should.
I'm
okay,
saying
what
the
is that?
test is under 307A9. A variance shall not be authorized unless, and then there are that there's on sufficient evidence that there will not materially be detrimental, and then there are 4 separate requirements under that.
Could I ask you, let's say the variance was simply to allow lots that were 1 foot narrower than the prescribed zoning ordinance, 2 feet, and it's going to be 2 lots. Are you saying that the board can't come in and say that's such a minor variance that we don't think there's a detriment to adjacent property owners?
If depending on what the evidence is.
But that's the evidence. Is just that
Okay.
it's a 2 foot. It's a 6-inch variance from what the zoning provision currently requires. And this property just happens to be a very deep property, so you're still going to have the acreage, 1 acre parcels, but you're going to be off by 6 inches. Do they not get to decide that's really not that detrimental to the rest of the neighborhood?
That's a factor that they could consider, but and I've cited the case.
But why isn't it a factor then if it's just, say it's an extra 50 feet or 60 feet? And that goes to if it's a factor and they can look at it and say, no, it's really not that big of a deal in light of all of these other properties.
I think it is a big deal, because if it's going to mean the difference of 1 house being built versus 2 houses and it affects the property.
I think you may have just answered the question I was going to ask you, which is what is the real issue here? When we talk about detriment, is it the number of houses or is it the shape of the parcels?
It's the number of houses, and because it's the number of houses, the zoning ordinance is set up to protect it. What if that had been that had been even deeper? Would you then be able to come in and say, well, we could have 4 1-acre lots that are right next to each other, and we're entitled to put those houses right there, 4 in a row, because it's meeting the 1-acre zoning ordinance? No. You've got to look at what it's doing to the character of the neighborhood and what it's doing to the appropriate property. I would like to reserve my remaining 2
Very
minutes
well.
and 30
Thank you.
seconds. Thank you.
May it please the court, my name is Jasmina Richter, and I'm here for appellee Corey Richter. Mr. Richter is the owner of the subject property. This is, the court has already mentioned the standard of review, and Mr. Warner, I think, recognizes that this court should not weigh the evidence, and even if it finds the facts not as persuasive, if there's any evidence in the record that would support the board's decision, the court should affirm the board's decision. And so Mr. Warner has taken the tact of arguing that there is no evidence in the record, ignoring the evidence that is actually in the record. But I think his arguments in his brief and his arguments today here are that he's not persuaded by the evidence. He doesn't personally find it persuasive, and he thinks that the letters submitted by the neighbors and his own statement provided without any basis or explanation is more persuasive. And so what he's actually asking the court to do is to reweigh the evidence and find that his evidence is more persuasive. And that is just not allowed under the standard of review, which is abuse of discretion.
What is the contrary evidence? I mean, there are all kinds of ways to speculate contrary to appellant's evidence, but what actual evidence is there in the record to the contrary?
So I'll start with the requirement that the variance should be granted if the 4 requirements for a variance are met, and Mr. Warner has only raised 2 of them.
I think I asked you a different question. What evidence is in the record contrary to Mr. Warner's?
On the materially detrimental
Yes.
part of the variance. So the evidence in the record, contrary to those letters, is one, what the variance actually is. And the applicant provided an explanation in his application for a variance saying, we want to go from 165 feet to 148 feet for the frontage. We're going to maintain the 1 acre. It's about a 10% reduction in the width. So just that.
How is that evidence as to detriment?
It's evidence as to detriment because it shows that the change is minimal. It's a barely perceptible narrowing of the property. So if you're arguing that there's a material detriment to adjacent properties, to neighboring properties, this isn't a standard that says, well, if they'd rather not, then we're not going to allow you to do that. No, the standard is materially detrimental to your property value. And so explaining what the variance is actually doing and that it's a minimal reduction in the narrowing of the property, the frontage, which from standing on the street, you can't even visually perceive that difference, that's relevant to whether it's going to have a materially detrimental effect on the properties.
It may be relevant, but did anybody actually testify or submit any written evidence on the issue of detriment? Not on the issue of whether this is visually de minimis, but on the issue of the overall detrimental impact, if any, of this proposed project on the neighbors.
Yes, Your Honor. And
Where is that?
so the applicant, at the board record at 10, he submits his application with an explanation. Then the hearing officer has a summary of what was testified to at the hearing, what was discussed. That's at 35 through 37.
Can you give me a quote or a summary of the best testimony on this point for your case?
Well, I was going to go on, and then before the board hearing, there was an additional written submission by the applicant, which is found at 111, where the applicant has a written submission, and he explains what the current plans are for the property. He explains that the lot width is 148, the minimum requires is 165. He attaches a number of exhibits showing the plat map for the property, showing what that reduction would do. There's other properties in the area, 44%, that are already that width. And so what the applicant is doing is he's showing that this change is not inconsistent with the neighborhood. It's completely consistent, and so it wouldn't have an impact.
Extrapolating that, the argument is that something that is consistent with the existing features of the neighborhood cannot by definition be detrimental. Is that the logic?
That is the logic.
Okay.
Yes.
Is there an explanation in the application that talks about the improvements to the property?
There is, and he also goes through an explanation of what the plans are for the property. So there's an explanation of here's what the property is today. That property is a dirt lot with an abandoned residence in the middle of the property. It's more than 2 acres. The home is uninhabitable, and we've cited in our briefs where there was a hearing at the board where all of this was discussed and there was testimony to this effect. And then in the written application, the applicant also discusses what the plans are for the property if the lot split is granted, and that is 2 custom homes, each on 1 acre, which is consistent with the neighborhood, consistent architecture, 4 to 4,500 square feet. There was also testimony at the zoning hearing that the custom homes would be upwards of $1 million, and that is found in the summary of the zoning hearing, which is also part of the record in front of the board and was cited to in our briefs. So as to the materially detrimental, there's the variance itself, that it's a minimal reduction. There's also the plat map showing that the variance and the split would result in 2 lots that are each 1 acre, consistent with the other neighborhood properties. And I have copies of the plat map if that would help the judges. I'm happy to provide those.
If I'm not mistaken, each would actually have a total area of slightly more than 1 acre?
That's correct, Your Honor. Then there was also an exhibit provided showing all of the surrounding properties that are also less than 165 feet wide, represents 44% of the properties. I think an examination of the plat map actually shows that there's more properties than were even listed on that lot. And so even the block where Mr. Warner's home is, there's some properties that are directly behind the ones that are less than 165 and have the same lesser width. And then the board also questioned Mr. Warner and the applicant about the state of the property now and what was going to be built if it was split. And so that testimony regarding there's an abandoned property, we're going to build 2 custom homes, was also something that the board can consider. So that's all of the evidence showing that there would be no detrimental effect. On the other side, Mr. Warner submitted his statement that he believes it would be materially detrimental to his property value. And when he was questioned about that by the board, Mr. Warner said, somebody on the board questioned him, why do you believe that? And he said, they should be the ones that are here with the studies saying that it isn't going to increase the value. This isn't going to decrease the value of their homes, of the neighbors. Of course it is. It puts 2 homes where you could simply put 1 home, and it's going to decrease the value of the surrounding properties. That's common sense. So that was Mr. Warner's explanation, and the board had that to consider. And then they also had a 1-page letter from 3 neighbors who said, this variance is going to have a materially detrimental impact on my property, without any further explanation, any basis, any support. And the board considered that, and they're entitled, in their discretion, to give that evidence as much weight as they believe is appropriate. And in this case, the board found that the other evidence, the plat map, what the variance is, the surrounding neighborhood being 1 acre, a lot of other properties having the same width, and also the testimony about what was planned for the property was more persuasive. The board correctly upheld the granting of the variance. I don't know if the court has any questions about the substantive property rights requirement, and I can certainly answer those or go into that a bit more.
It's your time. I don't
Okay.
think there's a question pending.
So the variance has to be necessary for the preservation and enjoyment of substantial property rights, and Mr. Warner argues that there was no evidence presented that this would impact a substantial property right. In fact, the applicant for the variance, in his written submissions and testimony in front of the hearing officer and in front of the board, had repeatedly said that the substantial property right was his right to have 1 dwelling per 1 acre of land. And so right now what they have is 2 acres, 1 dwelling. Most neighbors can have 2 dwellings each on 1 acre. And so that is the right that the applicant was seeking to protect. And I have citations to the record where the applicant repeatedly testified that he's trying to get the same rights as the neighboring properties. Again, it's much of the same evidence, the plat map showing what the surrounding properties are. It's the properties that have less than 165 feet width, but also have 1 dwelling on 1 acre of land. And I'd like to address Mr.
There are properties that have less than 1 acre.
I don't believe that there was anything in the record submitted to that effect.
Or just acre parcels, but some with narrower frontage.
Some were narrower, some were as narrow as 105 feet. I'd like to address Mr. Warner's argument that the board did not consider the adjacent property and whether this variance had a materially detrimental effect on the adjacent property. There's nothing in the record that would suggest that, and the standard of review doesn't allow us to go back and speculate what the board based its opinion on. Rather, the standard of review is if there's any evidence in the record that would support their decision as to the adjacent property, the decision should be affirmed. And in this case, all of the same evidence applies to the adjacent property. The evidence about the custom homes being built, the evidence about the surrounding neighborhood, the evidence that this variance wouldn't be anything different. It would be in conformity to the neighborhood, the evidence that the variance is very minimal, barely perceptible. So all of that same evidence applies the same way to the adjacent property. And there's certainly circumstances where maybe a variance would uniquely affect an adjacent property, such that evidence as to how that adjacent property is affected needs to be discussed. That wasn't the case here. And so all of that same evidence applies equally to the adjacent property. Mr. Warner bases his argument as to the adjacent property mostly on the fact that the board members and the zoning officer didn't repeat the entire statute when they were discussing this requirement. They didn't repeat materially detrimental to the to people working and living in the vicinity and adjacent properties and surrounding neighborhood and the general public. But I think the record is clear that the board did, in fact, consider all of that. That's all I have here.
Thank you very much.
Thank you, Your Honors. Peter Warner again. First of all, in addition to Mr. Richter owning the property, Mrs. Richter is on the deed as well. The court asked her at least twice for the evidence as to what evidence that it would not have a negative effect or would not have an adverse effect on the adjacent property. All she could do was cite the evidence as to what they were going to do to the property itself that they're seeking the variance on, not to the adverse property. What if they were going to build a $10 million?
I don't think that's all she said. This is circumstantial evidence from which one can draw inferences, but describing the consistency of the project with the surrounding lots and the not variances in the zoning sense, but the geometric variances between lots in the area is evidence from which one could make an inference. It may not be an appraisal, but why is that not admissible circumstantial evidence of detriment?
I think that certainly shows that is circumstantial evidence that it would not have an effect on the neighborhood, but that is not circumstantial evidence that it would evidence that it's not going to have an effect on the adjacent property. You can say you're going to, no matter, it could have been, maybe they're building just one house on the property that would be worth $2 million. I don't know. But you don't know unless you specifically address it. And there was no evidence specifically addressing the adjacent properties. That is a requirement.
Adjacent property owners are part of the neighborhood. It seems like if the evidence of what's in the neighborhood, doesn't that also at least bear on whether the adjacent property owners have been harmed?
No, I think you can present circumstances, what I was going to do with the hog farm putting in next door. That might have a very negative effect on the next door neighbor, but it wouldn't have an effect necessarily on the entire neighborhood. What's going on in the neighborhood is a separate requirement and test different from the adjacent property test. You need to look at that separately, and they didn't do it.
It's not mutually exclusive, and certainly if you can come in and say, unless the adjacent property owner says there's something unique about this property, that I'm the only one who's going to be able to smell what's going on in that property. That's not the case here. You're just suggesting that it's a property much like all of the others in the neighborhood.
Then I think the court is throwing out with due respect, is throwing out the requirement that each of these needs. You're going to be handing out variances like candy. These are to be sparingly issued. That's what the law says.
But would you agree that maybe the 1 acre part of it is more significant if they wanted to divide it? If it was if the width requirement was still met, but they wanted to have a half-acre parcel and build a road somewhere else, would that the width? Which, in your view, is more significant, the width or the acreage?
They're equally significant because that's what the zoning, when the city council passed the zoning ordinance.
But they don't seem to be equally significant in terms of the homes in the area. If they're all 1 acre, but the frontages vary. I
have to look. I don't think that's necessary.
When was the zoning placed on the property?
What?
When was this zoning placed on the property?
The zoning, I think it was around 1960. My time is up, but I think it was around 1960 before the current owner.
Okay, so it's been a while.
Yes.
Okay, thank you.
But I'm not sure because you look at the plat maps of the zoning of the Saguaro zoning district, and it may have even been a bigger requirement.
Okay, I'm just curious about generalities. All right. Thank you, counsel, for your arguments. Interesting case. Appreciate your assistance. The matter is now under advisement. We will issue a written decision in due course, and we'll stand in recess to allow our final argument to set up. Thank you.